This matter of Agramonte versus Local 461.
I'd like to reserve 5 minutes for my rebuttal. Thank you
Fine.
very much. Your Honors, I'm trying to think about where to start with this, because we have a situation where the court can either try to interpret, as other courts have done for 70 years, what this court in 1950 meant in the Martin case, or revisit the Martin case, which has been mentioned many times over the years whenever this issue has come before the court. We
addressed it 10 years ago in Palladino.
and you said that it may require revisiting, but we're not going to do it here.
Yeah, but the legislature's heard this over and over and not
Right.
acted on
But
it. And one would think they would if they thought we were interpreting
even-
their intent incorrectly.
Even so, we have a situation here where we have in the Poland case, which is older than the Martin case, this court said that the union constitution is a contract between the member and the union. We now have, according to the First Department, a contract that's not enforceable. What is a contract if it isn't enforceable? It's not enforceable, because when a union official violates the union constitution, whether it be around an election or anything else, he's not doing it, it's not all the members have voted to do that, it's the union official who's doing that. So we have a contract, the court says is a contract, it's been enforced as a contract in 100 cases since 1920, but it's not enforceable.
How many of those 100 cases are cases involving, I'm right in front of you directly.
I'm sorry.
How many of those cases involving interpretations of union contracts are cases in which the union was an unincorporated association?
Almost all except Lassonde. Every one except Lassonde. For some reason, the correction officer is incorporated as a not-for-profit corporation. Every other one, they're an unincorporated association. I represent 24 unions. They're all unincorporated
So because
associations.
and I may have missed something, but I tried to look through every one of the cases that you cited to determine whether they were unincorporated associations or corporations. And I could not find one that clearly was unincorporated. There were some you couldn't tell, and there were others you could tell were corporations.
Well, Your Honor, I'm representing to the court that other than Lassonde, where they say in the decision that it's an unincorporated association and labor union, that's a very unusual structure for a labor organization. They're all unincorporated associations, except a very, very, very small percentage. I'm saying that as a 45-year labor lawyer. That's absolutely how it goes. What we have here is a setting where, with respect to union elections, until 1959, and Professor Summers in his article talks about all the cases before, well, he talks about, it was a 58 article, so he's talking about everything before 1959. All litigation around union elections occurred in the state courts. Private sector unions, public sector unions, people were unhappy about the nomination procedure, how the election proceeded, who got to vote, who was qualified. It all went on in the state courts. And there's a plethora of decisions about union elections and where the courts had to interpret union constitutions. In 1959...
Counsel, I'm sorry, just jumping ahead a little. What union constitution provision specifically is alleged to have been violated here?
Well, we alleged here that there was a provision, the particular provision, that said that you can maintain your membership without paying dues for 6 months after you maintain your membership for 6 months after the last time you pay dues. That was a major underlying argument we made, and we said that in this particular case, the last time they had gotten paychecks was in December, dues had been taken out, the election was in February. I made that argument to the General Counsel of DC 37. The communications are in the record.
And what constitutional line, because my understanding of that dues provision is it allowed you to maintain your membership through some sort of a waiver process.
There were two different provisions. One which said that you maintain your membership for 6 months after a layoff. Second was You could also extend that by requesting a waiver.
Okay.
Two different provisions.
Okay.
So we had all these people, the whole group.
These members were past 6 months.
Right. So we have a
right?
situation where there are 1,175 summer lifeguards and 25 year-round lifeguards. They all pay dues to the union, they all work under the union contract. So the ones that work in the summer work May, June, July, August, September, and then they get some vacation pay and bonus pay in December. The others work year-round at pools, the 25 other people. So the fundamental, so this is not about, this is how do you interpret the Constitution and whether, if under prior case law, if the courts are interpreting union constitutions, they ask for fair dealing. The interpretation that was being put on the Constitution by the union was 25 people get to vote even though they govern 1,200 people. We think that that's an unreasonable, that's not fair dealing.
But that's not really, I mean, that's the effect of the interpretation, but the interpretation seems to be, at least on some literal level, good standing dues paying members get to vote and non-dues paying members don't get to vote.
But they ignored the part about the 6 months, which we allege, nobody ruled on it. It wasn't been ruled on in the lower court, it wasn't ruled on in the appellate court.
So as an allegation of fact in this case, you're saying that there were members who had paid dues within the last 6 months who were denied the right to vote?
Yes, absolutely, hundreds and hundreds.
Doesn't it have to be 12 months, or am I misreading that? The prior 12 months? So even if you give you the 6,
No, if they were people who had paid dues, May, June, July, August, September, December, and the Constitution said that you, after you're not paid, haven't paid your dues, you get 6 months. There's a 6-month period in which you maintain your membership in good standing.
Do you automatically get it, or do you have to request the
Well,
credit?
no, you don't have to request it. That's what the international Constitution says. The local Constitution, then it also has a procedure for asking for it beyond that, because some people are laid off, they want to maintain their membership. They may be on workers' comp, they may be injured and not getting workers' comp, they may not have any income, they don't want to lose their union membership, they can ask for it. We also had people in this case who asked for it. There was no way to contact the locals, so I sent them to the general counsel of the parent union and said, here, these people wanted, and they were sending their notices, and they were ignored.
Counsel, I'm sorry.
There were never factual findings made on either of those questions, because the court never got beyond the Martin question.
And I'd like to go back to Martin for a minute. So assuming we don't revisit Martin, what would your argument be under the Martin, Madden,
Okay,
Palladino cases?
So our argument is that this court saw fit in Madden to say, this is going to be an exception, given certain circumstances. The second department in Madden had already granted injunctive relief despite Martin, but then they had denied damages because of Martin. And this court said in Madden that they were going to allow, they didn't have to address the injunctive relief part because nobody had appealed it, but that was there. And then they allowed damages, and they said in that case that if we don't do this, that leaders can run amok, this is not a quote, they can run amok and undercut legitimate democratic opposition by disciplining people unfairly. And there would therefore be soon you would have no union democracy left. I'm paraphrasing,
And that
but that's
seemed
basically
to be,
what
as you say, in the damages section of Madden, right?
that was just with respect to damages. Injunctive relief didn't even come up because it wasn't appealed and had been granted by the second department. In this situation, if a member of, particularly it's either public or private, because you can't enforce a local union constitution in federal court. You have to go to state court. The federal courts let you enforce international union
But are
constitutions.
you asking for monetary damages here?
No, we were not asking for anything.
So why do you get to Part 2 of Madden at all?
Well, all I'm saying is this court didn't see Martin as this wall that said no relief. This court, the second department had already allowed it. This court didn't say, that might be an error, we have to even discuss it. They actually went further and said, we need to allow damages in order to deter this. If it's unconstitutional. But we're not, this is a case for injunctive relief. This is a case where we said to the judge, Judge Kelly, I believe it was, we want to stay the election. He had actually issued a stay, but we didn't know about it till the next morning. And then we asked him to overturn it after we exhausted internal union remedies, which had upheld what had gone on. Not the only money that potentially could have flowed out of it, and that's still an open question, I think, in the courts, is whether there would be attorney's fees at the end. All we sought was injunctive relief. So you now have a situation where a union official leading a union, they can decide not to have an election. We can't sue about it. I just had a case with the Amazon Labor Union, where I represent the opposition guys, where the president wouldn't schedule an election, even though the Constitution said there had to be an election 3 months after the NLRB certified the union. He said, nope, not having it. I couldn't go to state court. I had to come up with, concoct a federal theory, which was really not, the judge wasn't too happy with it, and luckily we settled because it was getting messy.
Sorry,
Of course.
Yeah, thank you. Just to make sure I understand the scheme here, it looks to me, if I'm understanding correctly, that there are two questions, right? One is, were the two individuals eligible to run? But I take it you were also raising a question about whether the seasonal individuals, some or all of them, were entitled to vote. Is that correct?
Yes.
Okay, and so it looks to me that in order to run, you have to have been in good standing for a year, and there's some question about the 6
Yes.
months and when it runs. And I see in both the local and the AFSCME Constitution language about 6 months and being in good standing. Do you have to, what in the Constitution speaks to what the requirement is in order to be eligible to vote, not to hold office? Is it just to be in good standing?
Can I answer that on my rebuttal so I could go flip through the pages? I wasn't.
Okay, and maybe answer one other question as well. It looks to me that in Article 3 of the AFSCME Constitution, Section 9, I read it as saying that the member is entitled to the 6-month credit upon request, and I thought you responded to one of my colleagues that you didn't have to ask.
I'll check that too on the.
Okay, thank
But
you.
I think what's really important here, there's this particular election and how you're going to apply it and whether those rules meet some standard of fairness that I think can be an issue in New York State. That's the relief with respect to that election. But the Agramonte decision itself doesn't say, because of the facts here, we're not going to let you go to court. It says, it establishes now it is the law. And I've had it cited against me in several other cases. You can't sue over a union election. And if this court lets Agramonte stand without addressing that question, even if it finds that on the merits we can't get anywhere, then that's it. A union president can say, we're not having an election. A union president can say, the only people who can run are incumbents. And there'd be no relief, absolutely no relief available. And what I was telling you about the Amazon union thing was, the president said, I'm not having an election. And 3 years ago, I would have gone into, 3.5 years ago, I would have gone into state court, taken the provision that said there shall be an election in 3 months and said, enforce it, judge. Now I can't do that. And I had to come up with some federal theory, and the federal courts say, unfortunately in the Second Circuit, that if everybody is denied rights, because in the federal courts there's a right to an equal right to vote, and the Second Circuit has said if everybody is equally denied the right to vote, there's not a violation of the LMRDA. So
Thank you.
we're left with nothing. I see my red light is on. Thank you.
So, counsel, can we start right there?
Sure.
And particularly, why should we read Martin to pose any sort of an obstacle to a suit that doesn't seek damages?
So, thank you, Judge. At the time that this court issued the Martin decision in 1951, where it explicitly said that its interpretation of General Associations Law, Section 13, applies to contract claims, equitable relief was a well-established form of relief available to plaintiffs in contract cases. And so I've just got a couple of cites for you on that point because I thought that you might ask that question. There is the Butler versus Wright case, 186 New York 259. There is the Wirth, W-I-R-T-H versus Hammett book Fair Booking, 192 NE 297 at 300. There is the Hayfie versus Lynch, 39 New York 298. That's an 1894 case. So the law of contracts at the time that this court issued Martin, was it equitable relief, was available in a contract claim? This court in Martin said it applies to contract claims. The only conclusion has to be that when Martin said that General Association Law 13 applies to contract claims, it was holding that it applied to contract claims regardless of the relief that the plaintiff was seeking. And the well-established precedent from the Third Department in the 1982 Mountier versus Bailey case is that in union election cases, Martin precludes the issuance of injunctive relief. That case has stood for 42 years. The Second Department in the Cablevision case, the 2015 Cablevision case, cited to Mountier for the proposition that the Martin interpretation of Section 13 applies to claims for injunctive relief. So we think, Your Honors, it's clear that the First Department got it right and applied Martin to claims for injunctive relief. If I may answer a question that Justice Halligan raised, and I think Your Honor asked where in the Constitution it addressed voter eligibility, and you would find that on page 37 of the record. It's Article 6, Section 10 of the local 461 Constitution. But what I would ask Your Honors to do is to look at two other parts of the record with regard to that, because one of the two big arguments that the appellants make is that the local improperly denied people the right to vote. First of all,
Sorry, counsel, did you
Yes.
say section 6?
it's Article 6, Section 10. It's at the bottom of
I
page
see.
37,
Thank
Your
you.
Honor. So you will see in the record at pages 76 through 79 the waiver requests. And the AFSCME Constitution, AFSCME is the parent of Local 461, and the AFSCME Constitution allows a member to request a waiver, but you've got to ask for it. And by the way, the language requiring a waiver to be asked for is at page 43 of the record. It's the top of page 43 of the record. And you will see that there are only two people who made requests, Mr. Butler and Mr. Ozcan. And you will see those requests in the record at pages 76 through 79. Now, AFSCME is the parent of Local 461. AFSCME has got an appeals process called the Judicial Panel. People call it the JP. The JP heard an appeal from the local's decision on the election, and it said that there were three people who made a request. So maybe there was two, and maybe there were three people who made a request. But you will see in the record at page 576 and 577 the tally of votes. The narrowest spread was 17 votes. So even if all three of those people made a request and it was granted and they voted, it would not have changed the outcome of the election. So in fact, the issue of voting is not really an issue, because the well-established principle in federal labor law, and we think it makes sense here, is that if you allege a violation and it could not have affected the outcome of the election, then there will not be anything done as a result. Now, with regard to the second argument that the appellants make, which is candidate eligibility, there are two candidates at issue here. Both of them were seasonal candidates, Petitioners Ozcan and Petitioner Sequeira. The only one who made a request for that waiver was Ozcan. Sequeira didn't even ask for it. Again, I urge you to look at the record, page 76 through 79. So Sequeira made no attempt to render himself eligible. Ozcan, he did make the request, but again, there were factual findings made by the Supreme Court, and you will see that in the record at pages 15, 16, 17, 18. Supreme Court made explicit findings that basically said you had to have 12 months of good standing in order to run for the office that both Ozcan and Sequeira ran for. Neither of them had 12 months of good standing. First of all, assuming that they both made a request, they didn't do it until February 22nd of 2021. And so they were asking for it retroactively. But obviously, if you're asking for it retroactively, then you weren't in good standing at that moment. You need it retroactive. But second of all, the record, this is both from the lower court's decision and then the AFSCME judicial panel decision, is that at most, they were paying dues for 10 months, assuming that you give them the 6 months. That's not enough to have 12 months of good standing. I want to address an argument that the appellants made, and the argument was, if you don't read Martin to allow these suits, then there will be no remedy. In this case, AFSCME, the parent union of Local 461, afforded these appellants a meaningful remedy. If you look in the record, you will see at page 53 the October 2020 decision of the AFSCME judicial panel.
But isn't that different than having some outside independent, entity or court able to review those kinds of claims?
Your Honor, it absolutely is different. And if I may, so in the federal system, which is what the appellants often cite to, there are a number of differences. First of all, here, the appellants sued the night before the election. In the federal system, there is no lawsuit available under the Landrum-Griffin Act, the Labor Management Reporting and Disclosure Act, until after the election. Second of all, in the federal system, the only person who can sue to upset a union election is the Secretary of Labor, and the Secretary of Labor does that post-election, and it does it pursuant to a detailed statutory and regulatory scheme. And the difference between this case and federal cases, and I go back to Palladino, Justice Rivera, I think you mentioned Palladino. In 2014, this court said, we reject policy arguments with regard to General Association Law 13. That is for the legislature to consider. The legislature has not done that. And what I would urge your honors to do is reject the attempt by appellants to legislate from the bench, but beyond that, to send it back to trial courts to have standardless reviews of union elections. And I say that because one of the arguments that the appellants make...
But isn't the standard your Constitution?
Your Honor, so that's true, but one of the arguments appellants make is that even though the Constitution says the election should have been in February, appellants strenuously argue it should have been done in June.
Yes, that's one of their arguments, but they have different arguments about failure to comply with the terms of your Constitution. Isn't that what courts do all the time, is interpret the rules?
Your Honor, in fact, courts often interpret contracts. That is 100% correct. But what I would respectfully say is, first of all, Martin made clear that with regard to unincorporated associations, it bars contract language, it bars contract actions. And second of all, again, I think the federal system is a good way to look at this. That is, there is a recognition there that unions are special creatures. And actually, although it's outside of the record, he's been practicing labor law for 50 years. I've got gray here.
45.
Sorry about that. I don't want to age you, Arthur. But I do think that it is a specialty, it is a special world. And so when the federal system passed the Landrum-Griffin Act to govern union elections, it provided courts and the parties with a detailed statute, and there are now detailed regulations. And so those types of line-drawing decisions are what this court said in Palladino are to be made by the legislature.
There's a case in between, right, Palladino and Martin is Madden, and Madden opens things up somewhat, right?
Actually, Your Honor, respectfully, no. So here's the key factual difference between Madden and this case. First of all, as this court recognized in Palladino, Madden is a narrow exception only applicable to expulsion cases. But second of all, the facts in Madden made the case. In Madden, the record was clear. Expulsion from the union meant that the plaintiffs could not work in their chosen profession. They were harbor officers in the Port of New York. Union membership was a prerequisite to working in that job, and the decision is replete with references to the fact that when the people were expelled, they could no longer make a living. So what Madden said is, if the union's going to expel you and take away your right to make a living, we will provide relief. There's nothing like that here. Since the federal system has issued the Janus decision, you don't have to be a union member to work. And so the facts that underpinned the Madden decision simply are not present here, and so there is no reason to expand Madden beyond where it is. And indeed, after Madden was issued, the legislature had the opportunity to modify General Association Law Section 13 to expand it to expand Madden. It hasn't done that. In 2018, the legislature modified the Taylor Law, which is the law that governs public sector labor unions in New York State. It modified the Taylor Law to modify a union's duty of fair representation. It didn't modify the Martin Rule. So I think that the only conclusion to be drawn from all of that is that the legislature has chosen to not overrule Martin. This court was correct.
Can I ask you, counsel, your adversary at pages 27 to about 30 of his opening brief has a list of cases in which he says relief has been granted, these are New York court cases, to address union constitutional requirements. And I take it your response, and I'm looking at pages 22 to 23 of your brief, is that some of these cases are not ones in which the question of Martin's applicability is teed up, and so, but are you contesting that the courts are involved in making decisions about these elections? I'm trying to understand what your response to that is.
So actually, Your Honor, you are 100% right. There are cases where state courts interfere in union elections. However, I think our argument on that, we make a couple of arguments. First of all, none of those cases that are cited in the appellant's brief address Martin, and I think that the law is clear.
Presumably because there was some view that it was not, you'd have to assume, perhaps there was a view anyway, that that was not a winning objection to make.
Well, actually, Your Honor, I don't know what was in the head of the lawyers. I don't know what was in the head of the judges. I do know that this court in the global reinsurance case said that a case is precedent based on what was decided. So none of those cases are precedent. And the single case that addressed it is the Third Department's Mountier versus Bailey case.
So may I ask you about that same collection of cases, the same question that I asked your adversary? Would you agree that those are cases in which those unions were all unincorporated associations?
No. So Lassonde versus Seabrook, which is the First Department case, there it was a not-for-profit. With regard to the unions in the other cited cases, I simply don't know whether they were unincorporated associations. Some of those cases aren't applicable because there the unions were plaintiffs, in particular the Ballas versus McKernan case, and some of those cases were discipline cases, so they were within the ambit of Madden. Thank you very much.
Just quickly with respect to what I promised to answer. So the International Constitution did set forth a requirement of making a request, and what we alleged in the complaint and in the supporting affidavits is there's no clear manner in which to make a request, and that the letters and correspondence show that I wound up forwarding these to the General Counsel of the union because the local union didn't have email, telephone, office, or any way to make any sort of request. But also, Article the Constitution also says that if you have not, after 2 months of not paying dues by the 15th of the month, you become ineligible, and we alleged that they'd all paid dues in December, and they were all not given notice or whatever about the meeting in February. 2 months hadn't passed, so there was an allegation there. We did not, the judge, the Supreme Court Judge Perry did not, it was a motion to dismiss. It wasn't a motion for summary judgment. There was no litigation of the facts. There was a motion to dismiss based on Martin, and whatever findings the judge made were not based on a contested set of facts or testimony or whatever. So I'm not sure that those findings were anything more than sort of background. The one thing I jumped up immediately when counsel said in the federal courts do not allow for pre-election cases. It expressly states in the Labor Management Reporting and Disclosure Act at 29 U.S. Code Section 483, all right to pre-election litigation is preserved. Only after an election is conducted do you have to go through the Secretary of Labor. And so lots of the cases that get brought, even to this day, in private sector unions, or at least until now, have been lawsuits to enforce rights under union constitutions in the state courts, because you can't enforce local union constitutions in the federal courts. They only have jurisdiction under 29 U.S. Code Section 185 over international union constitutions because of the way that statute is worded. So that here we'd have a state that where the federal government has preserved your right, knowing Professor Summers helped write the LMRDA, knowing that there'd been 40, 50 years of litigation since Pollen in the New York State courts, and they would put a provision saying, you can go to court here pre-election, but there's no right after this decision, there's no right to go to court. I also would urge you, Judge, despite what you said, you addressed it in Palladino, if one goes back to the General Associations law, because in 1950, this court in Martin was looking at a union official had libeled somebody, and the somebody sued the whole union. That's what had happened there. That's what they were addressing. But if you go to the General Associations law and the wording of the General Associations law, there's a lot of ors in it. I cited on page 20 of my brief. It says that any action may be maintained against the president or treasurer, you have to sue the president or treasurer, for any cause of action for or upon which a plaintiff may maintain such an action or special proceeding against all the advocates by reason of their interest or ownership, comma, or claim of ownership, either jointly or in common, comma, or their liability thereof, either jointly or severally. The court doesn't talk about the severally. So the General Associations law is allowing a lawsuit if there's liability, and it does say liability. It doesn't say, unless you read injunctive relief as a form of liability, it says liability jointly or severally. And what's amazing is that since Martin, you can sue a union for negligence. In fact, Hannon and I are on the same case, we're on the same side, where somebody is suing they sued a union for libel, got dismissed, but then they sued the union for negligently hiring or electing the president, negligently hiring. And the court there said, no negligence is allowed under Martin. Why would negligence, you can sue a union for negligently hiring, or if the president drives his car into your car, you can sue the union.
Counsel, why isn't the Montier interpretation of Section 13 with respect to that language controlling in a case like this? Specifically, I mean, their interpretation that this tells you that you can name an individual member, but it still requires several liability of the membership. It's just a way to make the job of commencing an action easier.
But here's where I think a lot, and I can't cite the case, and one of the things that the court said, I believe it was in not necessarily in Martin, but if the members delegate responsibility, the members delegate responsibility.
Yes. I remember that case too.
They delegate responsibility. If they delegate the responsibility to some officer, then they are taking an action as a group to allow that officer to make a decision. So union elections generally, 100%, the Constitution says the election shall be conducted by, and usually it's an election committee, either elected, selected by the president, whatever. So here, in this case, there was an election committee. We never knew who it was. There was an election committee that ran the election. In any union election, there is somebody Sometimes in elections I run, it gets delegated to a neutral. But somebody is designated by the members. Either the members ratified the Constitution or they voted at a meeting to elect an election committee. To say then that every action that election committee takes, no matter how unlawful, can't be sued upon unless every single member has approved it, which could never happen because the person whose rights are being violated won't have ratified it. So therefore, there could be a vote of 998 to 2, and Mr. Kolko can come into court and say, well, it wasn't ratified by 100% of the members, therefore it's lawful. It is so critical that this court, without even getting into the facts which need to be developed in that particular election case, and by the way, I think they're having their election next week. Mr. Agramonte is here. I think it's next week, so it's 3 years. We started this all 3 years ago. Unless this court doesn't say that there's a remedy for violation of a contract called a union constitution, at least in the union election context, just like we said it's in the context of a expulsion. And they didn't say only an expulsion, this court didn't say only in situations where the person might be barred from employment, because the language is pretty broad as to what this court said in the Madden case. It said, and I will end with this, it said, as is manifest and already remarked, a contrary result would have far-reaching consequences. If one wrongfully expelled, not wrongfully kept from employment, if one wrongfully expelled has no redress for damage suffered, little more is needed to stifle all criticism within the union. If you can't sue over a union official undercutting what it says in the Constitution about a union election, there won't be opposition, because unions will start declaring, well, we're putting it off for a year, we're putting it off for 2 years, and there's not going to be anything you can do about it. And some unions don't have parent unions at all, and some have parent unions that don't really uphold the law. Thank you.
Thank you, counsel.